I'm a realist. I've been doing this practice for over 35 years. I represent small employers, big employers, franchisees, individual solo practitioners, you name it. So I work with these folks, these companies in the trenches. You've heard a lot over the course of time through the governor and today about business and industry coming into the state. From out of state. Well, I represent those folks, and I can tell you we have a problem in the state because the cost of doing business here in the workers' comp area is more than most. And I will tell you bluntly, they are contemplating, do we stay or do we leave? Do we open up more stores, whether it's restaurants, stores, or do we not? And one of the big drivers is workers' comp. We are more expensive than most states. We fight them. We litigate it. We go to court a lot. And what we throw around very easily, you won't hear this on the other side, are penalties and attorney fees for everything that the employer does. Good faith, bad faith, fair mistake, whatever, you get hit. Now, some people may say, I've got a personal vested interest. Well, my interest is contrary to what I'm testifying today because I am trying to help reduce litigation. I'm a defense attorney. I work by the hour. I represent these companies. If this passes, this reduces litigation, reduces the time that employers and everybody has to go to court and fight this stuff. Right? We're trying to work things out. We're not advocating don't take care of your injured workers. Let's do that, but let's make sense of it. So I don't want to get overly technical, but I know some folks don't understand what this bill is about in the process. This is not a new law. This was put on the books in 2013, the preliminary determination hearing process. What this is gauged to do is keep these cases out of court, out of a trial, out of expensive litigation by providing a process for the judge to give an opinion to the parties to say, I think the employee deserves it, I think the employer deserves it, whatever that may be, you get that fair opinion from the judge. That's it. That's it. Get the opinion in front of the judge. So bear in mind, this was 2013. When this was put on the books, what has not happened yet? COVID, 2020. So let me tell you what works now. Adjusters don't go to a big, nice office building where there's a mail room and a fax room right next door, and that can happen easily. They work from home now. A lot of companies that do business in Louisiana, they're adjusters in one state, they're based in another. As long as they're licensed and take the course, they can do it. So you've got adjusters from their home who are trying to comply with this obnoxiously technical statute, which requires faxing. Who does fax anymore? Back in 2013, I guess we did. We don't do that anymore. This statute doesn't even allow the adjuster to email the required forms. Doesn't allow it. Or FedEx it. It's got to be faxed. It's got to be sent certified mail, the snail mail, right? So all we're trying to do is make a 2013 statute that's on the books. It's already there. You may hear argument, oh, it's not fair. It's already on the books. We're just trying to make it useful. The most honest thing I've ever heard from my friends, and I've got friends on the plaintiff side, is this. This statute is currently written to fail. They know it. They won't acknowledge it, but the technical requirements of the statute are a joke. How do I know that? Because I would say probably 8 or 9 out of 10 times it never happens because some technical glitch in the facts and this and the other doesn't go through. So this is ridiculous to not make this statute 2013 applicable 2026 to allow this dispute process resolution to get worked out to reduce litigation, drive down costs. If the judge gives an opinion, it usually gets worked out. Let's get that done. There's no good reason why this shouldn't pass. I will give you one. An old politician told me once, the answer is money. Now, what's the question? So that's what we're dealing with here. We're dealing with penalties and attorney fees. The other side doesn't want to give that up. They don't want this to get worked out. But at the end of the day, who does it cost? Everybody in this room, every business, every industry, every job, and the ultimate decision, do we stay in Louisiana or do we leave? This directly impacts it. I'm glad to answer any technical questions of how this works in reality with the bill, but what I'm telling you sums it up as succinctly as we can present. Thank you,
sir.